Per request, we will be including the bar questions. Agency. Definition. This was asked in 2003 bar, Article 1868. By the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another with the consent or authority of the latter. Purpose. The purpose of agency is to extend the personality of the principal through the facility of the agent. It enables a man to increase the range of his individual and corporate activity by enabling him to be constructively present in many places and to carry on diverse activities at the same time. What acts may be authorized? General rule: any act a man may do in person, he may do through another. Exceptions: personal acts, criminal acts, unlawful acts. Characteristics: agency as a contract. Consensual. It is based on the agreement of the parties, which is perfected by mere consent. An agency is consensual because the contract is perfected by mere consent. Article 1315. No other acts or no other act is required to perfect the contract. The contract is perfected upon the meeting of the minds, upon the object and the cause of the contract. Principle: it can stand by itself without need of another contract. All preparatory contracts are principal contracts as well. Preparatory: it is entered into as means to an end, that is, the creation of other transactions or contracts. Onerous: only if there is no stipulation to the contrary. The law presumes that the agency is for compensation. The one, either the principal or the agent, who alleges otherwise has the burden of proof. An agent may allege that the contract is gratuitous because if he committed fault or negligence, he will be judged with less severity. His liability will be mitigated. Bilateral: only for agency with compensation. An agency is unilateral if it is gratuitous because it creates obligations for only one of the parties, that is, the agent, or bilateral if it is for compensation because it gives rise to reciprocal rights and obligations. Nominate: it has its own name and is governed primarily by the Civil Code. Fiduciary character: the relations of an agent to his principal are fiduciary in character, since they are based on trust and confidence on a degree which varies considerably from situation to situation. Representative character: the agent renders some service or does something in representation or on behalf of another. Representation constitutes the basis of agency, as it is a personal contract of representation based on trust and confidence reposed by the principal on his agent. Agency is generally revocable. The acts of the agents within the scope of their authority by legal fiction are the acts of the principal. The actual or real absence of the principal is converted into his legal or juridical presence and is an essential element of a contract of agency. Essential elements of a contract of agency. Statutory elements. Number 1. A person binds himself to render some service or to do something. B, in representation or on behalf of another. And C, with the consent or authority of the latter. Number 2. Jurisprudential elements. 1. Consent. Consent of the parties to establish the relationship, whether express or implied. Object. It is the execution of a juridical act in relation to third persons. Representation. The agent acts as a representative and not for himself. Limitation. The agent must act within the scope of his authority. Tuason versus Heirs of Bartolome, 463-408. Consent of both parties. A person may express his consent. 1. By contract, Article 1868, orally or in writing. Number 2, by conduct, Article 1869. Number 3, by ratification, Article 1910. Number 4, by presumption or operation of law. That is, the law presumes that a person has authority to act for another in certain situations. For example, in law, partners are considered as agents of the partnership and of each other. Note, only the consent of the principal and agent are essential. Consent of the third person is not necessary. The third person is not a party to the agency, but a party to the contract entered into by the agent in representation of his principal. Principal, Article 1869. Other names: mandate, employer, constituent, chief. He whom the agent represents and from whom he derives authority, he is the one primarily concerned in the contract. A person who cannot legally enter into contracts directly should not be permitted to do it indirectly through another. Capacity of the principal. Generally, if he can act for himself, he can act through an agent. If any special capacity is needed, it is he who must possess it and not the agent, for the latter only acts on his behalf. He may be a natural or juridical person. An emancipated minor child can be a principal, so may a married woman. A husband, as administrator of the conjugal partnership, is in that sense an agent who can bind conjugal property subject to legal restrictions. Agent. Other names: attorney, attorney-in-fact, proxy, delegate, and representative. He who acts or stands for another. He is given full or partial discretion depending on the principal's specific command. An agent may have his own agent, who is thus referred to as sub-agent. Capacity of agent. His capacity is in general the same as in the law of contracts. That is, he must be able to bind himself, but only insofar as his obligations to his principal are concerned. An agent assumes no personal liability. Even if the agent is a minor, the principal having capacity assumes the agency is valid, provided he is not in estoppel. Between persons who are present, when is acceptance deemed implied? When the principal delivers his power of attorney and the agent receives without any objection. Article 1871. Is this presumption conclusive? No. The presumption of acceptance may be rebutted by contrary proof, such as the power of attorney. Power of attorney. This is an instrument in writing by which one person, as principal, appoints another as his agent and confers upon him the authority to perform certain specified acts or kinds of acts on behalf of the principal. Its primary purpose is not to define the authority of the agent as between himself and his principal, but to evidence the authority of the agent to third parties within whom the agent deals. Between persons who are absent, when is acceptance deemed implied? 1. The principal transmits his power of attorney to the agent who receives it without any objection. Number 2. When the principal entrusts to him by letter or telegram a power of attorney with respect to the business in which he is habitually engaged as an agent, and he did not reply to the letter or telegram. Note: mere silence of the agent does not imply acceptance of the agency if the letter or telegram is not related to the business in which he is habitually engaged as an agent. Object: execution of a juridical act. If the purpose of the agency is not to establish rights and obligations between the principal and a third person, it is no longer a contract of agency because the object of a contract of agency is the execution of a juridical act, one which would either create, modify, or extinguish a juridical relationship. An example of a juridical act by an agent is when an agent pays. Payment extinguishes the debtor-creditor relationship. Costs, presumed to be for compensation. If the agency is gratuitous, the cost is the liberality of the agent. If the agency is onerous, the cost, as to the principal, is the promise of service of the agent. As to the agent, the cost is the promise of the thing. Form 1869, 1874, 1878. General rule: there is no law requiring a contract of agency to be in a particular form for it to be valid. Exceptions: there are certain laws requiring the contract to be in a particular form. Those falling under the statute of frauds under number 2 of Article 1403 of the Civil Code, which requires that they be in writing or else it is unenforceable. 1. If a transaction falls under the cases requiring a special power of attorney, absence of which shall render it unenforceable. Note: the following cases shall render the acts of the agent void when there is no authority. 1. When an agent without written authority sells a piece of land or any interest therein, sale shall be void. Article 1874. 2. When the agent does not have a special power of a general and sufficient power to accept donation, donation shall be void. Article 745. Third, when a third person transacts with the agent who has exceeded his authority and such third party has knowledge of the scope of the agent's authority. Article 1898. Fourth, all acts of the substitute appointed against the prohibition of the principal. Article 1892. Agent's authority. The agent's authority may be oral or written. It may be in public or private writing. Rule: if the authority was made orally. The requirements of an SPA in Article 1878 and of a special authority in Rule 138 of the Rules of Court refer to the nature of the authorization and not its form. The requirements are met if there is a clear mandate from the principal, specifically authorizing the performance of the act. Such mandate may either be oral or written. The one valid thing that it shall be expressed. Importantly, if the SPA is not written, then it must be established by evidence. Limpin versus Liao Tan, 115 Scrat to 90. Under Article 1403, Number 2, Paragraph E of the Civil Code, an oral agreement of the sale of real property or of an interest therein is unenforceable even if there is no agent. If authority of the agent is not in writing and the agent entered into a contract of sale with a third person, the status of the contract between the agent and the third person may still be valid. As a rule, the contract will be valid and binding as to the principal. Article 1868. The principal may not be bound by the contract of sale if the sale is void. If a contract is a sale of an immovable property and the authority of the agent is not in writing, as a rule, the contract of sale is unenforceable because whenever the ownership of an immovable property is transmitted, a special power of attorney is required. Article 1878. However, if the immovable property is a parcel of land, the contract of sale will be void. Article 1874. Distinguished from other contracts, like partnership. Partnership to the extent of control. A partner's power to bind his co-partner is not subject to the co-partner's right to control, unless there is an agreement to that effect. While in agency, an agency must submit to the principal's right to control the agent's conduct in regard to the subject of the agency. Liability. A partnership, a partner acting as agent for the partnership binds not only the firm members but himself as well. Partners are solidarily liable in a subsidiary capacity. The assets of the partnership must be exhausted first. While in agency, the ordinary agent assumes no personal liability where he acts within the scope of his authority. How about sharing of profits under partnership? The profits belong to all the parties as common proprietors in agreed proportions, while in agency, the alleged owner or partner takes his agreed share of profits not as owner but as an agreed measure of compensation for his services or the like. The agent or partner can bind the principal or his co-partner only by such contracts as are entered into within the scope of his authority. In general, both conceptions import the idea of a fiduciary relationship. Each partner is regarded as an agent of his co-partners when he is acting as a principal of his co-partners when they are acting. A partnership is, in effect, a contract of mutual agency. The contract of partnership and the contract of agency are much similar. It is important to distinguish the two in order to ensure that there is no confusion. Lease of work service, Article 1644. Lease of work service between or versus agency. Basis of employment. The lessor, like a servant, ordinarily performs only ministerial functions. Lease of services contemplate only material, not juridical acts. Nielsen and Company versus Lepanto Consolidated Mining, where in agency, the agent exercises discretionary powers. The agent is destined to execute juridical acts like creation, modification, or extinction of relations with third parties. Under lease of work or service, only two persons are involved: the lessor or master of or employer, and the lessee, the servant or employee. The lease of service relates more to matters of mere manual or mechanical execution, which the servant acts under the direction and control of the master. While in agency, three persons are involved: the principal, the agent, and the third person with whom the agent has contracted. Agency relates to commercial or business transactions. In both agency and lease of service, one of the parties binds himself to render some service to the other party. Same case, Nielsen and Company versus Lepanto Consolidated Mining. A person may be employed to perform the duties of both agent and servant, that is, bookkeeper, who is also authorized to purchase office supplies, is in this respect acting as an agent. How about contract for a piece of work? Under contract for a piece of work, the independent contractor is authorized to do the work according to his own method without being subject to the other party's control, except insofar as the result of the work is concerned. That is in the case of Frezel versus Uichaco and Sons. While in agency, agent is subject to control and direction of the principal. Under contract of a piece of work, generally, the employer is not liable for the torts or injury inflicted by the independent contractor or by the employees of such contractor. Employer is liable only if injury is caused by his negligence or the result of his interference in the work of the independent contractor, or the work is intrinsically dangerous or a nuisance. While in agency, in general, the principal or employer is liable for the acts of the agent or servant within the scope of his authority or employment, applying the doctrine of vicarious liability. Both contracts involve service. How about negatorium gesture? Articles 2144, 2145. Negotorium gesture, not only without the authority of the owner or the business, but is without his knowledge. Acts according to the presumed will of the owner by exercising all the diligence of a good father of a family. It is also a quasi-contract, while in agency it's a contract, and acts according to the express will of the principal under agency, and under agency, representation is expressly conferred. In both cases, the officious manager or negotorium gestor or agent represents the owner of the business or principal. Under loans, 1933, a borrower is given money for purposes of his own, and he must generally return it whether or not his own business is successful. While in agency, an agent may be given funds for the principal or by the principal to advance the latter's business. Something is given to the agent or borrower. Sale under Article 1458, as in Bar 2000, sale versus agency to sell. Under sale, the buyer receives the goods as owner. The buyer pays the price. The buyer, as a general rule, cannot return the object sold. The buyer can deal with the thing as he pleases, being the owner, and the essence is the transfer of title of a thing from one to another. There is a transfer of possession of goods to the buyer, while in the agency to sell, the agent receives the goods as the goods of the principal. The agent delivers the proceeds of the sale. The agent can return the object in case he is unable to sell the same to a third person. The agent, in dealing with the thing received, is bound to act according to the instruction of his principal. The essence involves the idea of an appointment of one to act for another. There may be transfer of possession of goods to the buyer. Trust versus agency, Article 1440. Under trust, the title and control of the property under the trust instrument passes to the trustee who acts in his own name. A trust may ordinarily be terminated only by the fulfillment of its purpose, while under agency, the agent represents and acts for his principal. An agency may in general be revoked at any time. While trust is not an agency, it is possible for a trustee to be an agent also, where extensive direction and control are kept over the trustee. How about broker? One who is engaged for others on a commission, a negotiator between other parties, never acting in his own name but in the name of those who employed him. So under brokerage, a broker has no relation with the thing he buys or sells. He is merely an intermediary, negotiator, or middleman between the vendor and the vendee with regard to the real property subject of their transaction. He has no concern over the custody or possession of the real property. His only office is to bring together the parties to the transaction, never acting in his own name, but in the name of those who employed him. In effecting a transaction, he acts in a certain sense as the agent of both parties. A broker earns his pay commission merely by bringing the buyer and the seller together to obtain a meeting of the minds. While under agency, a commission agent is one engaged in the purchase of sale for another of personal property, which for this purpose is placed in his possession and at his disposal. He maintains a relation not only with his principal and the purchases or vendor, but also with the property which is the subject matter of the transaction. An agent receives commission upon the successful conclusion of a transaction such as sale. How about guardianship? Guardianship versus agency. The guardian, although he acts for and on behalf of his ward, does not derive his authority to act from the ward, but from the court who appointed him as such. The relation of guardian and ward may be created irrespective of the consent or capacity of the ward. Guardians are not subject to the direction of their wards. A legal guardian is substituted by law and stands in loco parentis. A guardian represents one who has no legal capacity to contract for himself, while in agency, agent derives his authority from the principal. The relation of principal and agent is founded upon the consent of the parties thereto. Agents are subject to the control of their principal. Ordinarily, an agent is the appointee of the principal, and his power may at any time be abrogated or modified by the principal. An agent represents one who has capacity to contract for himself. Bailment. Bailment, or the bailee, is possessed of no power to bind in personal liability. The bailee owes neither loyalty nor obedience to the bailor. The only obligation of the bailee is to safekeep or properly use the object deposited to him. Unlike in agency, of course, the agent may bind the principal. Agent owes loyalty and obedience to the principal. Classification of agency as to manner of creation. Article 1869. Agency may be expressed or implied from the acts of the principal, from his silence or lack of action, or his failure to repudiate the agency, knowing that another person is acting on his behalf without authority. Agency may be oral unless the law requires a specific form. Express agency, one where the agent has been actually authorized by the principal either orally or in writing. Implied agency, one which is implied from principal's act, principal's silence, principal's lack of action, principal's failure to repudiate the agency. Ratification may produce the effect of an express or implied agency. It results in agency by ratification. Note that in these cases of implied agency, the principal knows that another person is acting on his behalf without authority. General rule, agency is not presumed. The relation between principal and the agent must exist as a fact. Exception, agency may arise by operation of law. Agency may arise to prevent unjust enrichment. B. As to compensation, Article 1875. Agency is presumed to be for a compensation unless there is proof to the contrary. Gratuitous agency, one which the agent receives no compensation for his services, while onerous, one which the agent receives compensation for his services. Note, an agent may allege that the contract is gratuitous because if he committed fault or negligence, he will be judged with less severity if the contract was not for compensation. Compensation may be in the form of gratuitous use by the agent of the principal's real estate. Absence of stipulation, the agent is entitled to compensation only after he has completely or substantially completed his obligation as agent. Workers' compensation, a duly registered and licensed natural person who, for a professional fee, commission, or other valuable consideration, acts as an agent of a party in a real estate transaction to offer, advertise, solicit, list, promote, mediate, negotiate, or affect the meeting of the minds in the sale, purchase, exchange, mortgage, lease, or joint venture of other similar transactions on the real estate or any interest therein. If the broker does not succeed in bringing the mind of the purchaser and the vendor to an agreement with reference to the terms of the sale, he is not entitled to commission. So long as the sale is pushed through, the broker is entitled to a commission, even if the sale had been temporarily delayed due to the principal's lack of tact. He is not entitled to recover his expenses during the negotiations for the sale, such expenses having been incurred at his own risk and in consideration of the commission agreed upon. So when the negotiations through the broker's effort have reached such a stage that it would be unfair to deny the commission earned, the principal cannot revoke the authority he has given. There is evident bad faith if the principal breaks off from negotiations with the buyer bought or brought by the agent in order to deliberately deal later with the buyer personally. Justice demands compensation for the agent. A broker is entitled to commission on a sale affected by the owner or affected by the owner to the person produced by the broker after the breaking of the original negotiations if the breaking up was a mere subterfuge and a sale was in fact brought about by what the broker had done. This is the doctrine of procuring costs. As to extent of business covered, 1876, an agency is either general or special. The former comprises all the business of the principal, the latter one or more specific transaction. General agency, one which comprises all the business of the principal. Question asked in 1992 bar, special agency, one which comprises one or more specific transaction. As to the nature and extent of their authority, universal agent, one employed to do all acts that the principal may personally do and which he can lawfully delegate to another the power of doing. General agent, one employed to do all acts connected with a particular trade, business, or employment. Special agent, one authorized to act in one or more specific transactions or to do one or more specific acts or to act upon a particular occasion. As to scope of authority, as in 1992 bar, Article 1877, an agency couched in general terms comprises only acts of administration, even if the principal should state that he withholds no power that the agent may execute such acts as he may consider appropriate, or even though the agency should authorize a general or unlimited management. Agency couched in general terms, one created in general terms and is deemed to comprise only acts of administration. Example, general power of authority or general power of attorney, GPA, agency couched in specific terms, one authorizing only the performance of a specific act or acts. Note, an agency couched in general terms may be a general or special agency. As of its nature, ostensible or representative agency, one where the agent acts in the name and representation of the principal. Simple or commission agency, one where the agent acts in his own name but for the account of the principal. Apparent or ostensible agency, Article 1873. If a person specifically informs another or states by public advertisement that he has given a power of attorney to a third person, the latter thereby becomes a duly authorized agent. In the former case, with respect to the person who received the special information, and in the latter case, with regard to any person. The power shall continue to be in full force until the notice is rescinded in the same manner in which it was given. At the time the transaction was made, the principal has already revoked the agency, but as far as the law is concerned, the agency is still in full force and effect, and the principal shall still be liable if he did not inform the third person of the revocation. This is in order to avoid fraud. Giving notice to or giving notice of agency. By special information, the agent is considered as such with respect to the person who received the special information. By public advertisement, the agent is considered as such with regard to any person. It may be made in any form through newspaper, radio, etc., and by billboards or posters. Agency by estoppel. Article 1431. Through estoppel, an admission or representation is rendered conclusive upon the person making it and cannot be denied or disproved as against the person relying thereon. The principal cannot deny the existence of the agency after third parties relying on his conduct have had dealings with the supposed agent. Now, as to third persons, if the estoppel is caused by the principal is always liable. The agent is not personally liable. If the estoppel is caused by the agent, liable only if the third person acted on the misrepresentation. It is only the agent who is liable, never the alleged principal. If the estoppel is on the ground of negligence or fraud on the part of the principal, the agency is allowed upon the theory that when one of two innocent persons must suffer loss, the loss should fall upon him whose conduct brought about the situation. One who clothes another with apparent authority as his agent and holds him out to the public as such cannot be permitted to deny the authority of such person to act as his agent, to the prejudice of innocent third parties dealing with such person in good faith and in the honest belief that he is what he appears to be. For the following presumption or deductions, which the law expressly directs to be made from particular facts, are deemed conclusive. Agency by estoppel versus implied agency. Implied agency. Agent is the true agent with rights and duties of an agent. Reliance by third person is not necessary. But for agency by estoppel, agent is not a true agent, hence he has no right as such. Can be invoked only by third person who is in good faith, relied on the conduct of the principal in holding out the agent as being authorized. Agency requiring special power of attorney. This is asked in Bar to 1999. Article 1878. Special powers of attorney are necessary in the following cases. 1. To make such payment as are not usually considered as acts of administration. Number 2, to effect innovations which put an end to obligations already in existence at the time the agency was constituted. Number 3, to compromise, to submit questions to arbitration, to renounce the right to appeal from a judgment, to waive objections to the venue of an action or to abandon a prescription already acquired. 4. To waive any obligation gratuitously. 5. To enter into any contract by which the ownership of an immovable is transmitted or acquired either gratuitously or for a valuable consideration. Number 6. To make gifts, except customary ones, for charity or those made to employees in the business managed by the agent. Number 7. To loan or borrow money unless the latter act by urgent and indispensable for the preservation of the things which are under administration. 8. To lease any real property to another person for more than 1 year. Number 9. To bind the principal to render some service without compensation. Number 10. To bind the principal in a contract of partnership. Number 11. To obligate the principal as a guarantor or surety. Number 12. To create or convey real rights over immovable property. Number 13. To accept or repudiate an inheritance. Number 14. To ratify or recognize obligations contracted before the agency. Number 15. Any other acts of strict dominion. Definition refers to a clear mandate, express or implied, specifically authorizing the performance of the act, and must therefore be distinguished from an agency couched in general terms. Execution of a GPA or SPA does not need the intervention of any notary public to make it binding and effective. One special power of attorney needed. The acts referred to under Article 1878 can be reduced to 3. 1. Acts of strict dominion or ownership as distinguished from acts of mere administration. Letter B. Gratuitous contracts. And letter C. Contracts where personal trust or confidence is of the essence of the agreement. Reasons for the rule. In the cases enumerated under this article, they are classified as general acts of strict ownership or dominion and not merely acts of administration. Hence, the necessity of special powers of attorney, except in the cases expressly so mentioned, are or required. Note, sale of personal property falls under any other acts of strict dominion. Compromise. Judgment-based compromise agreement. A compromise agreement is a contract whereby the parties make reciprocal concessions, avoid litigation, or put an end to any one already commenced. Its validity depends on its fulfillment of the requisites and principles of contracts dictated by law, its terms and conditions being not contrary to law, morals, good customs, public policy, and public order. Requisites of valid compromise: the consent of the parties to the compromise. Letter B, an object certain, that is the object matter of the compromise and the cause of the obligation that is established. Effect of non-inclusion of party in a compromise agreement. The only legal effect of the non-conclusion of a party in a compromise agreement is that said party cannot be bound by the terms of the agreement. The compromise agreement shall, however, be valid and binding as to the parties who sign thereto. Contract of loan, as mandated by the foregoing provision, payment of monetary interest shall be due only if, number one, there was an express stipulation for the payment of interest, and two, the agreement for such payment was reduced in writing. Thus, the collection of interest without stipulation thereof in writing is prohibited by law. Spouses Albos versus Spouses M. Bisan. Effect of absence of specific authority. If an agent performs a transaction under Article 1878 without special authority, therefore, the transaction is unenforceable. However, the agent can still seek the principal's ratification. Dungo versus Lupenia, GR L 18377. Rights and obligation of agent. General obligations: act with utmost good faith and loyalty for the furtherance of principal's interest. Number two, obey principal's instruction. Number three, exercise reasonable care. For specific obligations, number one, carry out the agency which he has accepted. Number two, answer for damages which through his non-performance the principal may suffer. Number three, finish the business already begun on the death of the principal should delay entail any danger. Number four, observe the diligence of a good father of a family in the custody and preservation of the goods forwarded to him by the owner in case he declines an agency until an agent is appointed. Article 1885. And number five, advance the necessary funds should there be a stipulation to do so. 1886. Act in accordance with the instructions of the principal, and in default thereof to do all that a good father of a family would do. And number eight, not to carry out the agency of its execution would manifestly result in loss or damage to the principal. Article 1888. Answer for damages if there be in a conflict between his interest and those of the principal. He should prefer his own. Article 1889. Not to loan to himself if he has been authorized to lend money at interest. Article 1890. Render an account of his transactions and to deliver to the principal whatever he may have received by virtue of the agency. That is Article 1891. Distinguish goods by counter marks and designate the merchandise respectively belonging to each principal. In the case of a commission agent who handles goods of the same kind and mark which belong to different owners, be responsible in certain cases for the acts of the substitute appointed by him. Pay interest on funds he has applied to his own use. Inform the principal where an authorized sale of credit has been made of such sale. Article 1906, Article 1896, Article 1890, and Article 1904. It was asked in the bar, which is number 16, bear the risk of collection and pay the principal the proceeds of the sale on the same terms agreed upon with the purchaser should he receive also on sale a guarantee commission. That's Article 1907. Now, Article 1908, indemnify the principal for damages for his failure to collect the credits of his principal at the time that they become due. And finally, be responsible for fraud or negligence, Article 1909. To carry out the agency requisites, the agent must act within the scope of his authority. The agent must act in behalf of the principal. The act within the scope of his authority, that falls under 1881. Distinction between authority and the principal's instruction. So under authority, the sum total of the powers committed to the agent by the principal. It relates to the subject or business with which the agent is empowered to deal or act. There is a limitation of authority. These are operative as against those who have or charged with knowledge of them, contemplated to be made known to third persons dealing with the agent, while instruction, it contemplates only a private rule or guidance to the agent, independent and distinct in character. It refers to the manner or mode of agent's action. It is without significance as against those who neither with knowledge or notice of them. It is not expected to be made known to those whom the agent deals because it's just an instruction. The agent is not deemed to have exceeded the limits of his authority should he perform the agency in a manner more advantageous to the principal than that indicated by him, since he is authorized to do such acts as may be conducive to the accomplishment of the purpose of the agency. Now, with authority in principal's behalf, it's valid, principal is bound, agent is not personally liable. We apply Article 1883, generally not binding on principal. Agent and third person are the only parties except regarding things belonging to the principal. When it's without authority, unauthorized and unenforceable but may be ratified, it is valid whether or not the subject matter belongs to the principal, provided that at the time delivery is to be made, the agent can transfer legally the ownership of the thing. An agent must act within the scope of his authority. An act beyond the scope of authority given does not bind the principal. Death of the principal. General rule, the agent shall no longer carry out the agency upon the death of the principal, because death is a mode of extinguishment of agency. This is also based on the representative character of agency, such that the death of one extinguishes the relationship. Exception, however, if it should delay or the delay entail any danger, it's in Article 1884. Number 2, if the agency has been constituted in the common interest of the principal and of the agent, or in the interest of a third person who has accepted the stipulation in his favor. Article 1930, or number 3, if the agent has done any act on behalf of the principal without knowledge of his death, the act shall be fully effective with respect to third persons who may have contracted with him in good faith. To act on behalf of his principal, Article 1868, liability of 2 or more agents. In a joint obligation, each debtor is liable only for a proportionate part of the debt. If it is solidary, each debtor is liable for the entire obligation. The presumption is that an obligation is joint. This follows the general principle respecting solidarity. The innocent agent has a right later on to recover from the guilty or negligent agent. A person is not bound by the act of another when, number 1, the agent acts without or beyond the scope of his authority in the principal's name, and number 2, the agent acts within the scope of his authority but in his own name, except when transaction involves things belonging to the principal. General rule, the principal is not bound by the acts of an agent beyond his limited powers. third persons dealing with an agent to do so at their risks and are bound to inquire as to the scope of his powers. Exception, where principal's acts have contributed to deceive a third person in good faith. Article 1911. As in the bar 1994, where the limitations upon the power created by him could not have been known by the third person. Article 1900. Where the limitations upon the power created by him could not have been known by the third persons. Number 3, where the principal has placed in the hands of the agent instruments signed by him in blank. And number 4, where the principal has ratified the acts of the agent. General rule, a third person may hold the agent who acted beyond the scope of his authority liable for whatever damage he may have caused to the third person. Exception, a third person cannot set up the fact that the agent exceeded his powers if the principal has ratified or has signified his willingness to ratify the agent's act. Number 2, if the third person was aware that the agent was acting in excess of his authority, the contract is void and the agent cannot be held liable. Exception to exception. If the agent undertook to secure the principal's ratification and he fails to do so, the agent is still liable. General rule, the agent who acts as such is not personally liable to the person with whom he contracts. Article 1897. Exception, of course, if he expressly binds himself. Article 1897. And number 2, he exceeds the limits of his authority without giving the third person sufficient notice of his powers. Article 1897. And number 3, the agent is liable not only for fraud, but also for negligence. 1909. Despite the fact that the agent acted for himself, the law gives the third person a cause of action against the principal if the contract involves things belonging to the principal, because there might be a possible collusion between the principal and the agent. Also, it is usually the principal who has money. The third person may not recover anything from the agent, which is why the law permits the third person to have a cause of action against the principal. Doctrine of agency by necessity. An agency can never be created for necessity. What if, or what is created, is an additional authority in an agent appointed and authorized before the emergency arose. The existence of agency or other unusual conditions may operate to invest in an agent authority to meet the emergency, provided we use pure, P-U-R-E, provided, number 1, the agent's enlarged authority is exercised for the principal's protection. Number 2, the agent is unable to communicate with the principal. Number 3, the means adopted are reasonable under the circumstances. And number 4, the emergency really exists. To observe the diligence of a good father of a family on account of the goods received by him owned by the principal. Rule, if a person declines the agency, a person is, of course, free to refuse to be an agent, but the duty of the owner. Upon the other hand, the owner must also act as soon as possible by appointing an agent or by taking charge of the goods. To advise or to advance the necessary funds should there be a stipulation to do so. Exception, the duty to advance shall not prosper if the principal is proven to be insolvent. To render an accounting of his transactions and to deliver, Article 1891. Every stipulation exempting the agent from the obligation to render an account shall be void. Paragraph 2 of 1891. If the agent fails to deliver and instead converts or appropriates for his own use the money or property belonging to the principal, the agent is liable for estafa. Exceptions would be Article 1891. If the agent or broker acted only as a middleman, with the task of merely bringing together the vendor and the vendee like a broker, And number 2, if the agent or broker had informed the principal of the gift or bonus or profit he received from the purchaser, and his principal did not object thereto. And number 3, where a right of lien exists in favor of the agent. Note, the article does not apply to the case of solutio in debiti, for in such cases, recovery can be had by the payer against the agent himself. Therefore, the agent, for the meantime, can keep what he had been given to him by error, or to keep what had been given to him by error. Note, the forfeiture of the commission will take place even if the principal does not suffer any injury by reason of such breach of loyalty. It does not matter that the agency was a gratuitous one, or that the principal obtained better results, or that usage or custom allows the receipt of such bonus. Indeed, an agent has an absolute duty to make a full disclosure of accounting to his principal of all transactions and material facts that may have some relevance with the agency. Domingo versus Domingo. To be responsible for the acts of the substitute. It's asked in the 1999 bar, Article 1892. The agent may appoint a substitute if the principal has not prohibited him from doing so, but he shall be responsible for the acts of the substitute. When, number 1, when he was not given the power to appoint one. Number 2, when he was given such power but without designating the person, and the person appointed was notoriously incompetent or insolvent. All acts of the substitute appointed against the prohibition of the principal shall be void. Article 1721. Difference of subagent and substitute. A subagent is contracted by an agent to help him in the accomplishment of the purpose of the agency. When an agent appoints a subagent, he does not disassociate himself from the agency, while for a substitute, the substitute takes the place of the agent. The agent is responsible for the acts of the subagent, but is not responsible for the acts of the substitute. The right of action against the substitute is an exception to the general rule that contracts are binding only between the contracting parties, their assigns and heirs. Subprivity of contract, Article 1311. Prohibition or prohibited from appointing a substitute. Agent is liable if he appoints a substitute. All acts of the substitute shall be void. Not prohibited from appointing a substitute. Not given to the power to appoint the substitute. If the substitution has occasioned damage to the principal, the agent shall be primarily responsible for the acts of the substitute, but the agent will be liable if he acted in bad faith. Now, how about given the power to appoint, the principal has given the power to appoint the substitute. The principal designates the substitute. The agent may still be liable if he carried out the agency even though its execution would manifestly result in loss or damage. A person to be appointed was not designated. If the principal did not designate the substitute, agent will be liable if the person appointed is notoriously incompetent or insolvent. Article 1892 would be relevant if while the property is being managed by the substitute, losses were incurred by the principal. Where the agent was given authority, can the principal hold the substitute directly liable? Not always. The substitute may invoke as a defense that he has no privity of contract with the principal. However, by express provision of the law, the principal is given a right of action against the third person, Article 1893. Note, just because losses were incurred by the principal, the substitute may still not be held liable if he acted within the scope of his authority, exercised due diligence, and the reason for the losses was because of a fortuitous event. Can the principal directly hold the agent liable? It must be considered whether the agent is prohibited from appointing a substitute or not. If the agent is prohibited and he appointed one, he is liable. If the agent is not prohibited from appointing a substitute, there are two scenarios. If he was not given the power to appoint a substitute and he appointed one, he will be responsible for the acts of the substitute. If he was given power, it doesn't mean he's liable. The law states he will be responsible. But the agent will be liable if he acted in bad faith. However, it must be kept in mind that the agent is not the insurer of the business of the principal. Letter B, if the agent was given the power to appoint a substitute, he is still not necessarily liable. If principal designated a person to be appointed as substitute, the agent must still be liable if he carried out the agency even though its execution would manifestly result in loss or damage. Article 1888. All provisions should be qualified by this provision. A scenario where the principal designated the person but he should not have appointed this person because it would result in loss or damage if person designated is notoriously incompetent or insolvent. If the person to be appointed was not designated although he was authorized, he will only be liable if person appointed is notoriously incompetent or insolvent. Rules applicable to a commission agent. Factor or commission agent, one whose business is to receive and sell goods for a commission, also called factorage, and who is entrusted by the principal with the possession of goods to be sold and usually selling in his own name. He may act in his own name or in that of the principal. An ordinary agent need not have possession of the goods of his principal, while the commission agent must be in possession. General rule, the agent must hold the property only in the name of the principal. Where he violates that duty by mingling the property with his own, he becomes a debtor of the principal and liable to him for any losses suffered as a result of the mingling. Exception by custom, some agents such as actioners or auctioneers normally are permitted to mingle their principal's property with their own. Some agents such as collecting banks are permitted to mingle the funds of their principal depositor with their own and the property of other principals. If agent sells on credit without authority, the principal may require the payment in cash, but any interest or benefit from the sale or credit shall belong to the agent, since the principal cannot be allowed to enrich himself at the expense of another. Ratify the sale on credit, in which case it will have all the risk and advantage to him. The purpose is to prevent the agent from stating that the sale was on credit when in fact it is made for cash. Rules applicable to a guarantee commission agent. Guarantee commission agent, or one where in consideration of an increased commission, the factor of or commission agent guarantees to the principal the payment of debt arising to its agency. Number 2, it is the commission given in return for the risks the agent will have to bear in the collection of credits. Del creditor agent, the agent who guarantees payment of the consumer's or customer's account in consideration of a higher commission. The principal may sue the buyer in his own name, notwithstanding that del creditor commission, so that the latter's amount to no more than a guarantee. The liability of a del creditor agent is a contingent pecuniary liability, to make it in the extent that buyer fails to pay the sum due. It does not extend to other obligations of the contract, such as damages for failure of the buyer to accept and pay for the goods. The del creditor agent may sue in his name for the purchase price in the event of non-performance by the buyer. Note, when the agent is not liable, the principal's remedy is to proceed against the debtor. This article does not apply to a case where there is a guarantee commission, of course. Rights and obligations of the principal. Therefore, 1, to comply with all the obligations which the agent may have contracted within the scope and in representation of the principal. Number 2, advance sums necessary for the execution of the agency when agent so requests, liable for reimbursements regardless of the undertaking success whenever agent has advanced and has no fault, interest inclusive. Number 3, indemnify the agent for all the damages which the execution of the agency may have caused the latter without fault or negligence on his part. And number 4, pay the agent the compensation agreed upon or the reasonable value of the latter's service. To comply with the obligation contracted by the agent, that's Article 1910, the principal must comply with all the obligations which the agent may have contracted within the scope of his authority. As for any obligation wherein the agent has exceeded his power, the principal is not bound except when he ratifies it expressly or tacitly. If the agent acts wherein the agent has exceeded his power, the principal is not bound except when he ratifies it expressly or tacitly. And for number 2, to advance the agent, that's Article 1912, the principal must advance to the agent, should the latter so request, the sums necessary for the execution of the agency. So should the agent have advanced them, the principal must reimburse him therefore, even if the business or undertaking was not successful, provided the agent is free from all fault. And the reimbursement shall include all the sums advanced from the day on which the advance was made. General rule, if it was stipulated that the agent should advance the necessary sums but the agent didn't, he will be liable. Exception, the agent will not be liable if the principal is insolvent. And number 3, to reimburse, that is Article 1912, the principal must advance the agent, should the latter so request, the sums necessary for the execution of the agency. And that's being repeated. So we move to 1980. The principal is not liable for the expenses incurred by the agent in the following cases. 1, if the agent acted in contravention of the principal's instruction unless the latter should wish to avail himself of the benefits derived from the contract, when the expenses were due to the fault of the agent. Number 3, when the agent incurred them without knowledge that an unfavorable result would ensure, if the principal was not aware thereof. Number 4, when it was stipulated that the expenses would be borne by the agent or that the latter would be allowed only a certain sum. The principal is not liable for the expenses incurred by the agent in the following cases. That's it, when it was in contravention. When the expenses were due to the fault of the agent, when the agent incurred them without or with knowledge that an unfavorable result would ensure, if the principal was not aware thereof. Liability when there are 2 or more principals, that's Article 1915. If 2 or more persons have appointed an agent for a common transaction or undertaking, they should be solidarily liable to the agent for all the consequences of the agency. Requisites, there are 2 or more principals. Number 2, the principals have all concurred in the appointment of the same agent. Number 3, the agent is appointed for a common transaction or undertaking. Now, rights of third persons in incompatible contracts with agent and principal. The principal authorized the agent to enter into a specific contract over a determinate thing. The agent entered into a contract over such thing with A, but the principal also entered into a similar contract with B over the same thing. To determine who has the better right, the contract entered into must be identified first. If it's a contract of sale, priority in time. Priority in right will not apply. Article 1544 is the applicable rule. So Article 1544, if the same thing sold have been, or if the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first take possession thereof in good faith, if it should be movable property. Should it be immovable property, the ownership shall belong to the person acquiring it, who in good faith first recorded in the registry of property. Should there be no inscription, the ownership shall pertain to the person who in good faith was first in the possession, and in the absence thereof, in the person who who presents the oldest title provided there is good faith. So one of the third persons may suffer damage if such person filed an action for damages against both the principal and the agent. Agent's right of retention, specific only for those goods connected with the agency. Number 2, until the principal effects the reimbursement and pays the indemnity. Principal's liability for expenses. General rule, principal is liable for the expenses incurred by the agent. Exception AFUS, which are 1. If the agent acted in contravention, principal's instruction, when the expenses were due to the fault of the agent, when the agent incurred them with knowledge that an unfavorable result would ensure if the principal were not aware thereof, and S would be when it was stipulated that the expenses would be borne by the agent or that the latter would be allowed only a certain sum. Modes of extinguishment. This was asked in Bar 1997. Agency is extinguished. We can use Edward, Article 1990. Letter E, expiration of the period for which the agency was constituted. D, by the death, civil interdiction, insanity, or insolvency of the principal or the agent. W, by the withdrawal of the agent. Letter A, by the accomplishment of the object or purpose of the agency. Letter R, by its revocation. And letter D, by the dissolution of the firm or corporation. That is Edward. Expiration, death, withdrawal, accomplishment, revocation, dissolution. Revocation of agency by principal, Article 1920. The principal may revoke the agency at will and compel the agent to return the document evidencing the agency. Such revocation may be expressed or implied. General rule, agency is revocable at will of the principal regardless of the term of agreement, and the exception, of course, when it is coupled with an interest. Interest possessed by the agent not in the proceeds arising from the exercise of power, but interest in the subject matter of the power. Number 2, in the cases mentioned under Article 1927, and number 3, which was asked in the bar, when a bilateral contract depends on the agency. Number 4, when the agency means of fulfilling an obligation already contracted. Number 5, if the case of a partner appointed manager in the contract of partnership and his removal from the management is unjustifiable. Number 6, when there has been a waiver by the principal. Number 7, when the principal is obliged not to revoke. He can revoke, but he may be held liable for damages for breach of contract. And finally, when the revocation is done in bad faith. Principal may revoke but cannot prejudice third person. So what does agency coupled with an interest mean? If the authority of an agent is coupled with an interest, it is not revocable by the death, act, or condition of the principal unless there is some agreement to the contrary between the parties. An agency coupled with an interest may still be revoked if there is just cause. A mere statement in the power of attorney that it is coupled with interest is not enough. A mere indication in the power of attorney that the agency is coupled with an interest does not automatically make it irrevocable. The interest must be clearly indicated to make it irrevocable. Del Rosario versus Abad. Manner of revocation. Agent with general power. Notice in the newspaper of general circulation is a sufficient warning to third persons. How about agent with specific power? Notice is rescinded in the same manner in which it was given, Article 1872, Paragraph 2. Implied revocation by the act of the principal in appointing another agent for the same business or transaction. Number 2, by the act of the principal in directly managing the business entrusted to the agent. Number 3, by the act of the principal in subsequently granting a special power of attorney as regards to the same business or another agent, where he had previously granted a general power of attorney to one agent. Article 1926. A general power of attorney is revoked by a special one granted to another agent as regards to the special matter involved in the latter. The making and accepting of a new power of attorney, whether it enlarges or decreases the power of the agent under a prior power of attorney, must be held to supplant and revoke the latter when the two are inconsistent. If the new appointment with limited powers does not revoke the general power of attorney, the execution of the second power of attorney would be a mere futile gesture. Article 1925. When two or more principals have granted a power of attorney for a common transaction, any one of them may revoke the same without the consent of the others. As a rule, the appointment of an agent by two or more principals for a common transaction or undertaking makes them solidarily liable for the acts of agents in accordance with the agency. Hence, any of them can revoke the same without the consent of the other. Withdrawal of the agent from the agency. That's Article 1928. The agent may withdraw from the agency by giving due notice to the principal. If the latter should suffer any damage by reason of the withdrawal, the agent must indemnify him therefor, unless the agent should base his withdrawal upon the impossibility of continuing the performance of the agency without grave detriment to himself. General rule: the agent must give notice to the principal. Number 2, must indemnify the principal should the latter suffer damages by reason of the withdrawal. Exception: the agent bases his withdrawal from the impossibility of continuing the performance of the agency without grave detriment to himself. The fact that an agent institute an action against his principal for the recovery of the balance in his favor, resulting from the liquidation of the accounts between them arising from the agency, and renders a final account of his operations, is equivalent to an express renunciation of the agency and terminates the juridical relation between them. Article 1929. The agent, even if he should withdraw from the agency with a valid reason, must continue to act until the principal has had a reasonable opportunity to take the necessary steps to meet the situation. So even if the agent's withdrawal is for a valid reason, he must continue to act until the principal shall have reasonable opportunity to appoint a new agent in order to prevent damage and prejudice to the principal. Note: if the agent files a complaint against his principal, then he is understood to have renounced the agency because his act was more expressive than words and could not have caused any doubt. Death of the principal. The general rule: agency is extinguished upon the death of either the principal or agent. Exception: the agency is coupled with interest. The act of the agent was executed without the knowledge of the principal's death, and the third person who contracted with the agent is in good faith. Number 3, the agent does not act without the knowledge of the principal's death. Such act shall be valid and fully effective with respect to third persons who may have contracted with the agent in good faith. And number 4, of course, when there is unfinished business. Article 1884, paragraph 2. He must also finish the business already begun on the death of the principal should delay entail any danger. If the agent dies, the heirs must notify the principal. Number 2, adopt measures as the circumstance may demand in the interest of the principal. Note: if the agent dies, the heirs should inform the principal of such death. However, if the principal dies, his heirs have no obligation to notify the agent. Other modes of extinguishment could be novation, termination by mutual consent, termination by the lawyer. Canon 22, Rule 2201, Code of Professional Responsibility. A lawyer may withdraw his services in any of the following cases: when the client pursues an illegal or immoral course of conduct in connection with the matter he is handling; when the client insists that the lawyer pursue conduct violative of these canons and rules; when his inability to work with his co-counsel will not promote the best interest of the client; when the mental or physical condition of the lawyer renders it difficult for him to carry out the employment effectively, when the client deliberately fails to pay the fees for the services or fails to comply with the retainer agreement, when the lawyer is selected or appointed to public office, and other similar cases, or outbreak of war inconsistent of the agency, loss of the thing. General rule, the loss or destruction of the subject matter terminates the agency. Exception, if the thing lost or destroyed is capable of substitution, or B, in case of partial loss or destruction, the agency was extinguished by the loss of the thing which is the object of the contract. The agent was not held liable since the pendant was lost due to fortuitous event. The perpetrators need not be convicted for the agency to be extinguished. Mere proof as to the happening of the incident is enough. And number 6, insolvency of the agents. If the agent caused injury to the principal or third person, the injured party cannot go after the insolvent agent. This is a protection for the principal. And this ends our review on agency. Please forgive the blunders and watch out for the trust and partnership to be uploaded afterwards.